Back, everyone. I will be introducing Professor Emeritus Kaiser. Professor Emeritus Kaiser has been teaching courses, including the Child Protection Simulation course at Western New England University School of Law since 1998. In addition to her skills-based courses, Professor Emeritus Kaiser previously taught legal research and writing courses. She serves as a private counsel for the Committee for Public Service Counsel, representing parents and children in appeals of child welfare cases before appeals courts and the Supreme Judicial Court. In addition to her practice, Professor Kaiser has published articles in the area of child protection law. Professor Emeritus Kaiser has also worked with the Children and Family Law Program of CPCS to set up a pipeline program for WNE students who are interested in child protection law. Please join me in welcoming Professor Emeritus Kaiser.
Good afternoon. It's my pleasure to moderate this panel. We have 4 panelists. I will give each panelist a 5-minute warning when your time is almost up. So the first panelist is the Honorable Arose W. Nielsen, who was born and raised in Springfield, Massachusetts. She was appointed Associate Justice of the Hampden County Juvenile Court in 2017 and presides primarily in Holyoke and North Adams. She is the current Vice President of the Honorable Harry J. Elam Judicial Conference, which is formerly the Massachusetts Black Judges Conference, and co-chair of the Hampden County Juvenile Detention Alternative Initiative. Judge Nielsen's career in public service began in 2001 when she worked as staff attorney for the Community Legal Aid, formerly the Legal Assistance Corporation of Central Massachusetts in Worcester. Here she conducted outreach and community education, as well as represented disenfranchised populations in matters affecting homelessness, including housing, discrimination, domestic violence, immigration, and public benefits. In 2007, she was awarded the YWCA Catherine F. Erskine Award for her work with women and immigrants, and moved on to become a founding partner at Carvajal and Nielsen, PC. While at Carvajal and Nielsen, Judge Nielsen represented civil litigants in juvenile, probate, housing, and discrimination matters. She also served as adjunct professor at UMass Lowell. Judge Nielsen received her BA in comparative literature Russian language from UMass Amherst and her JD from Western New England College. That's what we called ourselves then. Thank you, Judge Nielsen.
Thank you very much, Professor Kaiser. First of all, I'd like to thank Western New England and the committee that organized this Color of Law event, as well as my co-panelists that are here with us today. And I'd like to begin by telling you a little bit about myself and my background to give you some perspective on the rest of the presentation. If we have time, I'm happy to take questions. So I grew up, as you heard, in Springfield, Massachusetts, and was a child consumer of what was then the Department of Social Services. My family had a social worker. We were assisted with emergency shelter. We depended on public benefits. My siblings and I were separated from each other and lived with non-relatives for a time. And we had supervised visits with our father, which, when facilitated incorrectly, can be a strangely artificial way for children and parents to interact, especially when they are being watched through a two-way mirror. So I spoke to a judge for the first time as a child when I had to testify about a restraining order between my parents. And that was a very harrowing experience. I have family that were involved in the CRA process, the termination of parental rights process, and the criminal process. My personal experience has been that the Commonwealth's Court is a system that, depending on your perspective and socioeconomic status, has the capacity and the power to either strengthen or weaken family units. I've also had the professional pleasure of working in the public interest, serving the underserved and disenfranchised since I began working as an attorney at Legal Aid, then as private defense counsel for care and protection cases, and I've been on the bench since 2017. So I suppose children of color can be resilient if supported in their communities properly. Now I'm going to give you a little history about the juvenile court and its related institutions as they relate to both civil and criminal matters. So in 1846, Massachusetts established the nation's first juvenile correctional system, which consisted of a boys' home. Over the years, the failures of this type of institution eventually led to the establishment of the Department of Youth Services under the Executive Office of Health and Human Services in 1969. And ever since then, DYS has evolved to include more rehabilitative services for youth, including a continuum of services that incorporate support from family, schools, and other community-based programs. And this model has definitely been improved over the years as the needs of youth are recognized and addressed. In 1992, the Court Reform Act created a single juvenile court with different divisions across the state and 42 judicial positions. The juvenile court currently has jurisdiction over youth who commit crimes between the ages of 12 and 18 in delinquency and youthful offender proceedings, over children requiring assistance petitions, those are CRAs, care and protection petitions, adults contributing to the delinquency of a minor, and failure to send children to school. We have jurisdiction over adoptions, guardianships, and termination of parental rights proceedings. And it is the mission of the juvenile court to protect children from abuse and neglect, promote opportunities for children to reside in safe, stable, permanent family environments whenever possible, to strengthen families when their children are in need of services, to rehabilitate juveniles, to protect the public from delinquent and criminal activity while holding offenders accountable, and addressing the harm suffered by the community and the victim, and to decide all cases fairly and impartially with dedication, integrity, and professionalism. So now I'm going to throw some statistics at you. According to the numbers kept by the state, and stay awake, these are interesting, I promise. The total number of children under 18 years of age in Massachusetts is approximately 1,362,000. And this number has varied by up to 20,000 children per year since 2017. It's varied up and down. So almost 13% of those children live in poverty. In 2021, about 59% of all children in Massachusetts were white, 20% were Hispanic, 9% were Black, 7% were Asian, 4% mixed race, and less than 1% were Alaskan, Native American, or Native Hawaiian or Pacific Islander. So in 2021, 22,654 children were the victims of some type of maltreatment. 28% of those children were 3 years of age or under. So think about that. Those children are generally pre-verbal and unable to self-report if anything at home is going wrong. So the percentage of children being victimized decreases, fortunately, as children get older. And in September 2021, over 9,000 children were in foster care and 755 children were adopted. So now here's the interesting part. Let's compare the numbers. Out of all the children in foster care in 2021, almost 14% were Black, as opposed to Black children comprising 9% of the children in the Commonwealth. Almost 30% of the children in foster care were Hispanic or Latino, as opposed to the state population at 20%. Approximately 7% of the children in foster care were of mixed race, as opposed to 4% of the general population of children. Only 42% of the children in foster care were white, which is less than the overall population at 59%. So from the numbers, it's pretty clear that children of color are disproportionately represented in the foster care system. Now, that's just the civil side of things. According to the Massachusetts Juvenile Justice Policy and Data Board, Massachusetts has one of the worst racial disparities for youth incarceration in the country, having the 11th worst Latinx white disparity, the 11th worst Black-white disparity in the country. And then in addition, we are number one in the country for having the worst Latinx white disparity in the country. So in Massachusetts, Black youth are 14.4 times and 7.1 times as likely as white youth to be detained and committed to the Department of Youth Services. Latinx youth are 9.3 times and 5.4 times, respectively, more likely than white youth to be detained and committed to DYS. So it's presumed that the disparities exist, at least in part, due to police practices, arraignment decisions by prosecutors, and sentencing decisions by judges. Now, here's the good news. There are many ways and systems developed to decrease the numbers and disparity. For example, civil cases can be assisted through permanency mediation, which helps parties and DCF come together and talk about solutions that can either prevent DCF from filing a care and protection petition or otherwise lead to reunification of families, or failing that, mediate permanent and stable outcomes for children in the care of the department. And in addition, there's been an effort to formalize a network with agencies that assist families through resource referral. Court staff and judges are becoming more trauma-informed and competent around the neuroscience of developing children and young adults, as well as the pathology of addiction. On the delinquency side, one example of a successful program is the Juvenile Detention Alternative Initiative, or JDAI, which is a DYS program dedicated to working with area service providers to find ways to support youth and their families. And the goal of JDAI is ultimately to find ways to prevent children from being detained. Another example of a great program is diversion. And there are several diversion mechanisms that we utilize in Hampden County. The clerk's office has utilized diversion practices. The district attorney's office here has a very robust diversion program. And judges have the discretion to offer judicial diversion. There is even a separate grant-funded program at the Gandara Center that provides diversion services for us. The benefit of diversion for children is that if successful, the youth avoids having arraignment on their permanent record. So these are all great ways to help reduce the disparity in juvenile justice and child welfare, but we still have a long way to go. Some information that we just don't have about racial factors involves individual judges' decisions. We also don't have reliable statistics regarding the district attorney's own diversion programs. And finally, we don't have information about whether these existing programs improve factors related to education, housing, health, and recidivism for children who are not committed to DYS. So summarily, we need to consider some of the national research which indicates that system involvement does not necessarily improve outcomes for children in the criminal context. Another area we can work on is having more judges of color appointed to the bench. It's very important for our youth and families to see people who have some type of affinity with them when they walk into a courtroom. And it would also serve as a positive example for our young people, both in the system and not in the system. So that being said, Professor Kaiser, I don't know if we have the capacity to take questions at this point. Oh, I'm sorry, you're on mute.
Sorry about that.
Okay.
I think we were going to leave questions to the end. So if people can save their questions for Judge Nielsen until the end, that would be great. Thank you so much.
Thank you.
Okay, next on our panel is attorney Kisha Jones, who began her legal career in 2001 as a solo practitioner. Her practice consisted primarily of court-appointed state intervention child custody cases representing children and parents against DCF, probate, divorce, child support and custody cases, as well as personal injury cases. In 2016, Attorney Jones joined CPCS, the Children Family Law Program, as a supervising attorney. In that role, she works with new attorneys, interns, and fellows to introduce them to the practice. She currently supervises 3 staff attorneys and 2 new hires. She also engages in EID work with CPCS to foster diversity and inclusion within the Public Defender Agency. Further, she frequently assists the training and department in ensuring that the defense bar have the skills to be zealous advocates for the families we serve.
Good afternoon, and I want to echo Judge Nielsen in thanking you for having us all present. And I do want to say that she stole some of my thunder with her statistics, but we're going to carry on. So I want to talk today about how important it is to have a DEI lens in the hiring for all positions within the child welfare system. And I'm going to speak today based on my experience of working in the system and being a member of the global majority. Now, the child welfare system impacts all families, regardless of their ethnicity, gender orientation, gender identity, religious beliefs. Everyone is impacted by the system because the system was created to ensure children are safe and to ensure that families have what they need when necessary to make sure their kids are okay. But unfortunately, this system is steeped in the racism of the past within our society. But here's some good news. Today, America seems to understand that DEI is important. It helps all of us have a better life. And so the agencies you see represented here today, as well as other agencies across the country, are engaged in a lot of initiatives to foster diversity and inclusion. And so that is a cause for celebration because that is not a mindset that we had when I was like in high school, oh, so long ago. But despite all of these positive things, it is important that we continue to have these conversations so that we continue to be reminded about why DEI is important, okay? Now, the policies of the child welfare system were written with a clear intent to protect children. The policies on their face are benign. The problem comes with the implementation and how they are being, I want to say assessed, right? So despite all the initiatives, the employees remain overwhelmingly European in all of these systems, and they remain entrenched in an American culture. But unfortunately, the global majority is not European and not necessarily of American culture. And our society in America is very diverse. So these standards are being applied to families who do not share the European American cultural standard. And sometimes it brings negative results. As Judge Nielsen discussed, that there are the stats that she shared were similar to the ones I seen for the national level in 2019 from the Child's Bureau for the Child Welfare Information Gateway Bulletin for professionals dated April 2021. They had the exact same statistics that Judge Nielsen shared with us. And further, they found that Black families are more likely to be subjected to 50 reports of suspected abuse and neglect and investigations. They further found that Black children were more likely to be removed from their family of origin. They spend more time in foster care, and they are more likely to be subjected to termination of parental rights cases than their European counterparts. And the reason I find this concerning is because there was no accompanying evidence that this is because Black parents do a worse job at parenting. So we have clearly some disparities that exist within the system. And even though they exist, I think the fixes that are available are just simple. But before I discuss those, I do want to share a few examples of how a lack of cultural awareness can have a negative impact on a family. At the start of my career, I represented a Russian Orthodox family. They had recently migrated from Russia. Maybe they had been here 2 years. They lived in a community that was full of people who had the similar faith to themselves. So this father spanked his teen daughter for constantly skipping school and engaging in what they determined to be inappropriate contact with boys. The child went to school, had a slight mark on her arm, The teacher inquired, "Hey, what happened?" And the child says, "Well, my father gave me a spanking the other day and I must have hit my arm on something." That led to a 51A report, and that led to the immediate removal of the child. The fact that the child was not concerned about suffering the abuse was seen as she's a total victim because she's justifying the abuse. When we went to go to evidentiary hearing, members of that community, as well as their religious leader, came and explained to the court about their views on parenting and discipline. Because, see, the parent was not thinking he was being abusive. He did not use a weapon to spank the child. He spanked his daughter to get her to listen, because he had been telling her to go to school for months and she just kept skipping without giving him a reason that says she felt unsafe in school or unhappy. She just didn't feel like going. And the child was returned home. In another case, a Black mother was being represented by a European attorney who was a friend, and she had got a report for abuse for spanking her teen son for stealing from a store. And when her attorney inquired as to why did she use physical discipline, she said, "I could spank my son or the cops could kill my son." What the attorney found surprising was that I immediately understood what the mother was saying, and I explained that in the Black community, we have a concern that if our children do not respect authority and follow rules, they can end up dead. It's not as simple as going to jail. So many parents will use physical discipline to get through to their children out of fear, not out of an intent to abuse. Now, I've shared these examples not to say that I support abuse. I am a defense attorney, and I would never support children being beaten in an abusive manner. But I share this to say the cultural norms of both of these families were that that's not abuse. But when viewed through the European American lens, that any physical discipline is wrong, it was seen as abuse. And what's interesting is after I had those cases in 2015, the Supreme Judicial Court in Commonwealth versus Dorville actually showed how you can broaden your lens, keep children safe, and still allow for cultural sensitivity and understanding. In that case, they prescribed the standards and the way to assess when corporal discipline is actually abuse or appropriate discipline. So we have the capability as a state and a nation to broaden our lens. So it is important that we do that, and that these kinds of meetings and conversations make us aware of that need. And I would say, as a defense attorney, it is hard for you to represent someone zealously, in my opinion, if you cannot understand why they make the decisions they make and respect them. And I think the best way for you to be able to do that when you are representing someone different from yourself is to have a work environment that includes people who are different from yourself. When you work around all different types of people who have different beliefs, ethnicities, gender identities, you begin to see people different than yourself as human beings worthy of understanding and respect. They are no longer just an amorphous object off in the distance that's, you don't know who they are. And it's important that the defense side definitely has that ability, because we are client directed. We need to zealously advocate for our clients based on their stated positions. And if we do not respect our clients, we do not respect their positions, which hinders the advocacy that we're doing. We may think that our client's choice is the wrong choice, but that is not respectful of them as a person. So I want to continue to encourage everyone here today to always wonder, do I have a bias when you are dealing with someone different from yourself and you need to make decisions for them? I want to continue all of us who work at these agencies to continue to engage in the work to ensure that we have diversity and inclusion, because it's in that way that we are going to be able to better protect children, their connection to their families and culture, and better support parents to get the services they need to keep their family intact. Thank you.
Thank you so much for that. Our next two presenters are from the Department of Children and Families. First, attorney Cummings-Garcia started her legal career in 2005 as an assistant public defender for the Office of the Public Defender, 15th Judicial Circuit of Florida. The next stage of her career was spent as a private attorney representing clients in child welfare proceedings as well as other practice areas. She currently works for the Department of Children and Families as an assistant regional counsel. Diana Dawkins is another native of Springfield, and she completed her undergraduate degree in criminal justice with a minor in human services at Northeastern University in Boston. She then worked for a specialized foster care agency for 10 years as a case manager before becoming employed with DCF. Currently, Ms. Dawkins is the area director for the Springfield DCF office. She has held positions as ongoing social worker, investigator, supervisor, area program manager, and area clinical manager. In 2012, Ms. Dawkins was the recipient of the DCF Commissioner's Award following the events of the tornado that hit the Western Mass community. Ms. Dawkins has experience working with children and families in several different venues that include foster care, parenting programs for incarcerated mothers, support groups for secondary caregivers, sibling connections, and homeless families who were displaced in hotels. Ms. Dawkins is a 2013 Springfield College MSW alumni. During her time at Springfield College, she was selected as a distinguished graduate of the weekend program, was the convocation's guest speaker for the MSW program, and is a member of the Phi Alpha Honor Society. After graduation, Ms. Dawkins continued her education through the Springfield College Postmaster's Certificate Program in Advanced Practice with Children and Adolescents. Her work has continued in the social work field through the National Child Traumatic Stress Network as a cohort of forecasts, foundations for outreach through experiential child advocacy studies training. Ms. Dawkins is committed to her family and faith as a proud member of the St. John's Congregational Church here in Springfield. She was also an adjunct professor at Elms College in the social work department. Her passion has always been and will continue to be helping children and families in the community.
Good afternoon, everyone. Thank you, Professor Kaiser, and I also want to acknowledge and thank Honorable Judge Nielsen, as well as Attorney Jones and my partner, Attorney Cummings-Garcia, for allowing us to be present today. This is a very prevalent conversation that needs to be had, so the fact that you've allowed this venue to occur, we are gracious and appreciative of that as well. For me, I just wanted to give a little bit about myself. I know my bio was just read, but I just wanted to put in context, working for the Springfield DCF area office as the area director. For me, representation matters. The community that we cover is primarily Black and Brown youth. And we also cover the Longmeadow, East Longmeadow catchment area, but majority is Springfield. And throughout my tenure here with the department, we have not had a person of color running this office in over 10 to 12 years. So to have this recycled and come back where I was given the opportunity to be blessed to do this, I welcomed it with open arms, just because, as you know, the judge has mentioned, as well as, you know, an attorney has mentioned, representation truly does matter when we're talking about this population that we serve on a daily basis. What I wanted to discuss a little bit today before Attorney Cummings jumps in is in regards to where the department stands today, where we want to be headed in the future, and how that really does involve with diversity and what that looks like. The judge was very accurate in sharing her stats. The Springfield area office is it's the second largest office in the state. We have the most children in care, and those children are children of color. And you ask yourself, why is that? Are we out there in particular searching, looking for children of color? No, we're not. But that's who gets reported to us. So when you really take a minute to pause and take a step back and think about who's being filed on, it's disproportionate. It's family of colors that come across either the police officers or the school truancy officers or, the therapists. That's who's at the forefront. So they get filed on. Where in other communities, say if a mother gets pulled over for drunk driving, they may slide that under the rug. But in the city of Springfield, it's a woman of color. Oh no, they're going to file on her because she had kids in the back seat. So there's a difference when an officer in East Long Meadow is going to drive that mother home and make sure she gets there safe versus Springfield's going to call and file on those kids. So that's the reality that we're dealing with. And it's rather unfortunate because child abuse is across the gamut. It is colorblind, but the actual reporting is not. That's the difference. So the ways in which cases come to our attention is obviously through 51A reports, and that's concern of obviously abuse or neglect of children, through mandated reporters or anonymous folks that want to file, but also CRA, as the judge mentioned, child requiring services if it's a teenager who's struggling at home or truancy matters. And then we also have voluntaries where families are just struggling and they need some assistance. So the way the process works is once the report comes to us, it's either screened in or screened out. And we decide at that point, does the family really need the department's intervention, or can we utilize community resources? Because stats show once we're involved, it takes quite some time for us to be out of your life. And it's our goal is to see stability. Our goal is to make sure that families can be strong and stable, but it takes a lot longer than it should for families to be involved with the department. And it also shows that once you're involved one time, there's this generational cycle that continues in Black and Brown cultures of children being involved with the Department of Children and Families. That doesn't necessarily happen in European cultures as well. So the department has taken, I'd like to say, some growth. We have made some changes in our initiatives. We have made some changes in our policies where we've updated so that the family's voice is actually at the table, that they're actually to be heard, and that it's a collaborative approach. We want to make sure that we do have a lens of DEI so that it's not just our own implicit bias and that we actually are culturally competent. And we're buying into it and just not saying it, but actually doing the work so that we are using appropriate interpreters. We're using community resources so that they feel comfortable talking in their language or someone that can understand and help work with us as providers, and that we ourselves are becoming educated around it and just not making assumptions and having our own implicit bias put forth on these families. We really have changed our policies to reflect around the language, the cultural, gender identity, socioeconomic status, and disabilities. We have all new policies geared around this so that we can see that the families are actually being impacted in a productive way versus in a stereotypical way, to put it lightly. I know that there was a case example that was brought and shared with you, an affidavit in regards to a primarily bilingual family, Hispanic family of 2 that we wanted to talk about for a little bit. And again, the case came to our attention in this affidavit where there was a little child that was burned accidentally because of hot water. And we'll get into that. Then there was a teenager who was being truant. And then we had concerns of possible domestic violence between mom and dad arguing. And when mom and dad argued and the child was in the high chair screaming and crying and the worker tried to do some intervention, the child fell. So at that point in time, the department decided to do an intervention, and that was a legal intervention. And when that happens is we have gathered all the facts that we believe, we've contacted all the collaterals, and we try to make an informed decision if children are safe at home or if they require to become out of home out of placement. And that's when we pull in our great attorneys and we do legal consults. So with that being said, I'm going to pass it the baton to attorney Cummings-Garcia so she can share the legal aspect of working with the department, and then I'll chime back in.
So when the department decides that it's going to do out-of-home placement and we decide that court intervention might be warranted, they do a legal consult where they discuss with the attorney what evidence might be presented and whether or not reasonable efforts are met. And one of the considerations of reasonable efforts is whether culturally appropriate services were provided to the family. So in the case of the affidavit that we had today, we have a Jamaican mother, we have a Hispanic father, and we have a different fact pattern. So one of the things that as the attorney we do, we look at the fact pattern, We decide whether or not we think one was the abuse or was their neglect. But we advise and we counsel our clients. And one thing that we do over a period of time, not just like with this fact pattern, but with this case, is we ask the hard questions. Is there something else the department could have done in the case? Is there implicit bias? Is there something going on that's being missed that could prevent that removal? And also, sometimes we have a case where it's already court involved, and we will have attorneys who will contact us and they will say, this social worker has a bias against the parent. This social worker is doing this or doing whatever. Department is aware, and we'll talk, and Diana will get into this. There might be biases. There might be issues. We do not just ignore concerns. We will bring it up. We will address it. We will look to go see, could there be a bias? Could there be something else in the interaction that is being done and how this family is being serviced or addressed? Because part of our task is to work with the family if we do a removal, to make sure that the family is reunified if that is going to occur. We don't just remove a child and say our goal is to take this child forever and not reunify the child. We're hoping that we can place this family back together and make them whole. Unfortunately, sometimes it doesn't happen. But I just want to touch on something that Attorney Jones mentioned about how important it is to have like a diverse set of attorneys involved in a case. You can tell I was a defense attorney for many years. And one thing I realized is that clients appreciate having an attorney who could speak Spanish, who looks like them. And I think working for the department, it makes a difference when you have an attorney who has a diverse background when you're analyzing the case and when you're looking at it. And I think our agency has been doing a good job when it comes to trying to recruit people to work within the agency and to try to develop a diverse panel of attorneys, a diverse panel of staff within the agency, because I think the agency recognizes that diversity is important. And I mean, if you look at the Springfield area office legal, we are a very diverse office when it comes to the legal staff. And I think the agency recognizes that. And I think it makes a difference in how we view the case. Like I just wrote the fact pattern. I'm Jamaican and my last name's Garcia, so my husband's Spanish, so I speak Spanish. And when you look at the case through the lens, you analyze it and you look at things, and there might be things when it comes to a cultural aspect that someone else might miss when they review an affidavit that you might not. And one of the things that agency that we're trying to do all around is to make sure we look at the cultural aspects, we look at everything and make sure the family is being serviced properly. So we're going back to Diana to talk about what the agency is doing when we do have a diverse family, how to address the cultural aspects.
So thank you. We have done a robust amount of training, a robust amount of education for our staff, and there is very targeted hiring that is actually being done so that we can actually represent the community that we service. I started by saying how important representation is and that it matters, that we need to have bilingual staff. Even within the Latino community, you may see we have a migration of Guatemalan families. It's not the same as when we have, Dominican staff who are trying to understand, the Spanish language that they speak. So there's diversity among those that are also, diverse. So we have to make sure we're addressing all of those needs and what that looks like. We're also making sure that we're being culturally sensitive to the fact of we have had a huge Somalian population, for example, that have been brought here, and either some of them are refugees, and we've tried to make sure that we can make sure that they have stable housing, that they're safe, and that we have a good understanding of their cultural norms when it comes to disciplining their children, so that we're not making assumptions or our own implicit bias about what that looks like for child protection. And when we talk about making sure that the providers in the community that they're connecting with also understand their culture. But we have come across incidents where you will have a Somalian family and the Somalian community is the one that they don't want to know what is happening in their household. And that's the only Somalian therapist we can utilize. or that's the only one that can do parenting services to them. So we want to make sure that we have a clear understanding and that we don't assume, oh, because I'm Somalian, I want to have a Somalian therapist, because they may want to keep their stuff private as well. So we want to be respectful. I think a lot of today's takeaway has to be around representation and education. And the department has definitely shifted with that, with the increase of our policies, really making sure we're covering all aspects of diversity, including disabilities. We don't want to forget that as well, because that often comes up. But one of the other examples I wanted to make sure that I shared with folks is when children do come into care, their safety is always paramount. It's never a good feeling for social workers, despite what people may think, but we know that it's our job to keep children safe. And if we feel we can't do that after all the supports we put in place, then we will have them come into care. We file the care and protection, and then we assume custody of these children. And then our goal is always to work towards reunification first and get that parent to work towards having their child reunified with them. And what does that mean? We want to be able to work collectively. And when the children come into care, they will do better and they will reunite and be successful when we place them with kin. And it is really our initiative to try to ensure that, guess what? I'm with Auntie Diana. So at least I'm not in stranger foster care. I'm in foster care with my family. So my food, my holidays, my culture is still being represented and not lost by placing kids in homes that they have no connection with. And the department has really shifted in that thought process of realizing children need to be connected. They are beyond resilient, and we will make them even that much stronger when they're connected with kin. And I will admit, our policies in the past were not user friendly. They were very black and white. They were very strict. They were, oh, you have a Corey from 20 years ago for marijuana in your car. You cannot have your niece or nephew placed in your home. That's it. And I'm proud to say we have grown. I honestly think that COVID has helped us shift, because we had to start to think outside the box. And what do? We realized that's what benefited kids, to let them go with grandma who had a Corey from 20 years ago. It's better to have her with grandma than to have her with a stranger, because guess what? She can still be able to have connections with mom, her other siblings, her aunties, her uncles, that she would lose all of that if she was placed in a stranger's foster home. So diversity is having the staff, having the education, making sure that we're utilizing the appropriate services to meet the needs of the family in front of us, and acknowledging and owning our implicit bias from the department. And then when it involves a removal, making sure we're meeting the cultural needs of those children that come into care. And that includes the entire family unit, working with the aunties, the uncles, and not forgetting about the paternal side of the family. There is a whole nother side of the family that often goes without being contacted, or if they view them as not as user-friendly, not as engaging based on history, but we still need to include those family members at the table so that the children's diversity in their cultural needs and cultural competence doesn't get lost through the work that the department does. And I have to say, we have great partnerships with hiring and education and trainings, as well as with our attorneys, who also, if they view the facts and help us realize where we could have erred on the side of caution or where we could have done things differently when we're trying to make sure that family can either be a unit or reunite sooner than later, because we've done the proper steps to make sure children are safe.
And don't forget that we have foster parents who are also being trained to be more culturally sensitive when children are being placed with them, because we do have children who sometimes are not placed in a similar cultural home as theirs. So we have to be cognizant of that fact. So we are doing trainings with the foster parent to be more culturally aware, and we are trying to see if we can expand the foster parent base.
Absolutely. Thank you, because you bring up a really good point. I actually have one of my staff who runs foster parent trainings to help how to care for children's hair of color, how to braid, what that looks like. And no question is a silly question, because that's going to make the child feel good about themselves. And we want to make sure that a recruitment of foster parents are inclusive. So when you say that you open your home to any child, what does that actually look like when you're talking about their religious beliefs And what that may be, their connection to their parents, their connection to food. I don't think people realize how important connection to food is for children when they come into care and when they're not eating and what that looks like. And to make sure we have foster parents that are open to learning as well, and they actually buy into it, they believe in it, and they utilize it. Not just, oh, I went to the training and I packed it away, but we actually make sure staff are having the day-to-day conversations with them, because each foster home also has a social worker assigned to them to make sure that these things are being addressed and just doesn't fall to the wayside, on top of the child having social workers and the parents having social workers work with them as well.
I think that's it for us.
Yeah.
Thank you. So I think Andrew's going to help me check to see if there are questions. Okay. So this isn't a targeted question for specific panelists, but I would ask if through your years of practice in this area, have you noticed positive changes that have helped to close the gap to these gross disparities? If so, what are some of these developments? For example, policy changes or in-house seminars?
I'd just like to acknowledge that for every case that the court sees, there are so many that we don't, and that is a credit to the work that the department does to screen out cases that don't need to be filed in court. So, so that's one consideration. And also, we have some excellent defense attorneys who are able to, you know, through a mediation process or a pre-filing process, really be able to help clients and the department come together and come up with viable solutions other than filing.
Anyone else want to add to that? So I have a question, if you don't mind. I think a trend in child welfare legal work is a sort of a pivot to more social work oriented means of intervention. And I know in our area, Community Legal Aid has started a program that involves both legal advice to parents who are involved in the system, as well as social work assistance. And I'm wondering, you know, if you see a future in that kind of social work legal combination that might be able to address some of these situations.
Well, I will say that my agency, my office has, we have staff social workers that assist the attorney and the client outside of the services that DCF provides. So I do think that the more supports that families have access to is going to be helpful. And if those supports are receiving the training about bias and are open to cultural differences, it can only be a positive. The program you're talking about, I will never see that personally because that's done pre-court filing and it should not be a part of the court filing. But I am aware of that program, and I have been told that they do have success in helping families. And so if you know, there's just a lot of different things that come into place with regards to access and services, right? So we're in Western Mass, we don't have a lot of money out here. We don't have a lot of services. So sometimes even with the best of intention, it falls apart. The case gets filed in a court, and that's when I get involved. I'm not aware of that other work, but then we are able, even the private bar attorneys can access a social worker to help their clients. So I do think that social services, along with legal help, is the way forward. And I do think as long as lawyers are litigating and social workers are helping, that families are winning.
I'd like to add to that, just to make it clear that attorneys on their own can do some limited social work, and they're not clinicians. They should not ever be considered clinicians. However, being able to do, a little bit of referrals, following up with your client to make sure they made the phone calls that they need to hook up with services, that's all a part of zealous advocacy. And it really helps the court to know when a licensed professional is testifying, that we can rely on the services that that licensed professional and the opinion that if they are qualified as an expert, the information we can rely on.
I'd like to add that I believe that programs such as the Community Legal Aid Program are helping families from getting court involved. And I think that's a benefit to the families if they can have that assistance ahead of time to work with them, where sometimes they're not as sophisticated and navigate in certain areas on their own, and they can get that additional assistance to work with us. They can get, so Community Legal Aid does have social workers, and they do have staff that will work with the families. And from what I've seen, they have managed to keep the families from getting a CMP filed against them. So it has been benefiting the families to have that engagement and that involvement with them. So there is benefits to having programs like that on the front end.
And if I can just say really quickly, I think the bigger picture here is all about having a trauma-informed lens. So when you actually have a social worker working with a family before it has to take that step is very important. And there are great benefits to it. Even once legal is involved and they still have a social worker from the attorney's office working with them, they're able to manage all those other pieces that aren't legal related that actually makes the parent feel better when they're addressing what's happening. One of the biggest or worst things a parent can go through is the loss of their child. So if their child is no longer in their care and custody and what that looks like, that does have an impact on you. So I think there is a role for a social worker in an attorney's office that is very important that they play in trying to help the client on all aspects of what has brought them before the court.
Thank you. So the only thing I would like to say before we leave this panel is that Attorney Jones, I think you might have had some of our students as new trainees and fellows, and there is, as far as I know, still a crisis council in Western Massachusetts, a very bad one where children and parents in Hampden County in particular can't readily access counsel. So I'd like to say to any student who is online or in this room right here, this can be a very rewarding field of work. We have a pipeline program here at Western New England that can lead to a fellowship that can help you transition quickly to this line of work. I know that DCF is also looking for new attorneys. And so I really want to encourage students to think about doing this type of work. If you want to be in a courtroom, you will be in a courtroom. I think we can guarantee that, right?
And I want to say, no, DCF has enough lawyers. So most definitely, please look into any internships, clinics. I know that there was a clinic that my office assisted with some students last semester, and I think they're doing it again this semester. And even though Judge Nielsen and attorney Cummings-Garcia defected from the defense side, they would have to agree that that work was rewarding. Your clients do appreciate you. They do appreciate your efforts. And there's plenty of work. So by all means, please, 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 please consider becoming part of the panel and getting involved.
If I can just jump in here, this work is so incredibly important and so incredibly rewarding, especially if you build your skills in other areas of law, such as housing, public benefits, probate and family, you know, all of those types of cases that affect our disenfranchised populations. It's really helpful to have that knowledge under your belt, even if it's just issue spotting. So I just want to encourage people to get out there, look at other practices in other courts. Because sometimes people walk into a juvenile court and it feels like you're in another world as compared to other courts, but you can only help yourself. You can only improve your practice by getting basic knowledge and really understanding the rules of evidence as they apply in other courts as well as in juvenile court, because it is a little bit different. But thank you to everybody who's considering a career in juvenile justice.
Yes, it is a very rewarding. I've been on the appellate panel for, I don't want to age myself, so I won't even say for how many decades, but it has really opened up a world for me, and it has been always a great experience. So thank you very much, and I'll turn it back over to Andrew.